11:30 we have begun.
Surely, surely, sir. Take your time, sir. No problem, sir. Take your time.
Smriti ma'am. Smriti ma'am. Hello.
Yes, sir.
We can start now. And today with us from University, Srini sir is here from Department of Engineering and IT and Computer Science and IT से हमारे साथ हैं अरविंद sir. So to address, you can request Srini sir and Arvind sir. So before that, the necessary formalities I am requesting to Smriti ma'am to please carry on, Smriti ma'am, please.
Yes, sir. Sure, sir. Good morning, respected delegates, esteemed guests, my dear faculties, and my dear students. A warm welcome to you all to a webinar session which is held about the topic of intellectual property rights today. So before starting the event, as we begin with the blessing of Goddess Saraswati, so let's evoke the event with lamp lighting ceremony.
Ah शिशु है अज्ञानी माता, किन चरणों का प्यार दे। तेरा पानी तार दे, तार दे, माँ सरस्वती शारदे, माँ सरस्वती शारदे।
Thank you. Moving the event forward, let's take a small glance on Arkajan University, Jamshedpur, which has evolved through a very less time and is on its way to reach its heights among the to reach the top universities in the Eastern India. So let's take a glance on Arkajan University, Jamshedpur.
Whether it is school, higher education, or postgraduate entrepreneurship, the discovery of mind is very important. Learning should be fun, learning should be creative, and we should try to assimilate thoughts in such a way, and this is where the youth is empowered here to see that he looks forward and tries to contribute not only for himself but to the society as a whole.
Arka Jain University, Jamshedpur, came into existence about a year back, that is 2017. I hope and pray that this Arka Jain University, which came into existence about a year back, will be a center for excellence in the days and years to come, not only in India but in international level.
Hello everyone. So Jain College in Arka Jain University is a fascinating story. It's a story of basically ordinary people doing very extraordinary things. In a very small classroom, that the journey that we are starting with 34 students will reach here. That we will be conducting our commencement day in the biggest auditorium in the city. And that's how today we are here. So entrepreneurship is the DNA of the Arka Jain University and the JGI group. If you look at the JGI group, we have integrated more than 100 companies, which has a turnover of more than 4,000 crore.
In Arka Jain University, we want to focus on the students and the teachers. What we feel that when students come into the campus, then they should get a unique experience. We have produced many sports personalities.
We have well-equipped library like computer lab, engineering lab, fashion designing lab, mass comm lab and bioscience lab facilities for the students to enhance their practical knowledge.
Without setting the goal, nothing is possible. Kindly I request you, first of all, set the goal and try to achieve. Arka Jain University try to help achievement to your goal and provide a highly qualified and experienced faculty.
One of the most important phase of every individual is the college life, where a teenager drifting into the ocean of new beginnings and possibilities. I'm studying here since 1 year and I had a great experience studying in this university. I'm going to talk about the stereotype, how people think that girls cannot take admission in mechanical or electrical branches because it's totally made for boys, and this university broke this stereotype by giving admissions to all the students as girls or boys. They have equal opportunities for studying in all the branches.
Hello, here Dr. Jyotirmaya Sahu, Dean of School of Pharmacy, Arka Jain University. School of Pharmacy is trustworthy. You will definitely like the lovely campus in a pleasant environment with world-class infrastructure, well-equipped laboratories, library with large range of books and journals, highly qualified faculty. You are one of a kind, so are
I am a student of School of Pharmacy of this university. We are the first batch of B Pharma of 60 students of this university. But we feel no such pressure of the first batch because of the constant guidance and support of our faculties. And the best part which I feel is that we have a separate library for our department only with the best publications.
About my college, I would just like to say you that the truth of the college is something beyond it. Here with good education, you will learn moral and ethical values which will help you to achieve your goals.
Thanks for the video. May I request Ashwini sir to kindly address the gathering?
Hello.
Yes, sir. Over to you, sir. Please proceed, sir.
Good morning, all of you.
Good morning, sir.
Firstly, congratulate to the School of Pharmacy and the IPR sale of the IGIU.
Sir, आपका your mic get unmuted, sir.
Hello.
Yes, sir. You are audible, sir.
हाँ सर, आवाज जा रही है सर?
Yes, sir. Yes, sir.
हाँ, good morning, all of you.
Good morning, sir. Good morning.
हाँ, good morning.
Good morning, sir.
हाँ, many congratulations to the School of Pharmacy and the IPR sale of the AJU, and also congratulate to the Dean, Dr. Jyotirmaya Sahu sir, for giving me opportunity for addressing the gathering in the occasion of the coronavirus and patent barriers, that is the intellectual property right. Firstly, think about what are the intellectual property rights. There are two types and two distinguished types of the copyrights. that is the copyrights and right related to the copyrights and the industry property. This is the intellectual property rights refers to the creation of the mind, such as inventions, literacy, and artistic works, design, and symbols, names and image used in the recent scenario. What is the intellectual property right and what are behind of the intellectual property rights? The rights of the authors of literacy and the artistic work, such as books and other writing, musical compositions, painting, computer programming, and films are protected by copyright for a minimum period of 50 years after the death of the authors. Also protected through copyright and related rights are the rights of the performers and broadcasting organizations. The main social purpose of the protection of copyright and related rights is to encourage and reward creative works. There are second thing is the industrial property right. What is the industrial property rights? One area can be characterized as the protection of the distinctive signs, in particular trademarks. That is the protection of such distinctive signs aims to stimulate and ensure fair competitions and to protect consumers by enabling them to make informed choice between various goods and services. The protection may last indefinitely, provided the sign in questions continue to be distinctive. Thanks to all. Thanks, Sahu sir. Thank you.
Thank you, sir.
Okay, sir. Welcome.
Thank you, sir. Now may I request Arvind sir to kindly address the gathering.
Yeah. Hello. Good morning, dear students. Am I audible?
Yes, sir.
Okay. So, dear students, good morning. I'd like to thank the Dean of the School of Pharmacy, Dr. Jyotirmay Sahu sir, for inviting me and giving me this opportunity to have a chat with the students. I'd also like to welcome the speaker of the day, Ms. Andrea Fernandez. She will be giving you the details and explanation on the topic today, coronavirus and patent barriers. So, for last 8-9 months, we all are facing this pandemic, and there are a lot of research work going on this pandemic, which is vaccines, medicines, and all these things. We go through news and different channels and everything. So we need, the purpose here is about the patent barriers and intellectual property right, the topic. We need to understand, to respect the people who are working on this. Just one example I'm giving. We need to respect the people who are working on getting the vaccine and medicine of this coronavirus. So similarly, not only on this topic, any research for you all the pharmacy students, in future, few of may go for job in some industry, few may pursue higher education and go for PG and doctorate degree and all. They may continue with research and all. So these students, you all students need to understand the importance of this patent right and property right, intellectual property right, so that you will be aware कि आप जो research कर रहे, the research which you are going to do on certain area that need to be respected throughout, not only in the country but throughout the world. So okay, so this way the guest speaker will be giving the complete details. I am just giving one brief introduction on it, and I am again thanking the Dean sir, Jyotirmay Sahu sir, for inviting me and giving the opportunity to speak on the topic. And dear students, I will just suggest you to kindly carry a diary with you now and make a note what the speaker of the day is going to tell you all these things. Okay, thank you.
Thank you so much, sir, for your words. Taking the event forward, today for the webinar session, we have with us Andrea Fernandez, who is holding a master's degree in intellectual property law and biotechnology respectively. She has done her PG diploma in patents law. She holds a graduate degree in LLB and microbiology and biochemistry, respectively. She is an advocate and a practicing patent and trademarks agent. She is working in the field of IPR for the last 14 years. She has been a resource person for various IPR seminars and lectures in India. We welcome you, ma'am, to the virtual platform of School of Pharmacy, Arka Jain University, and would like to request you to kindly enlighten the event with your golden words. Over to you, ma'am.
Thank you so much. Thank you for inviting me. I feel honored to be part of this session, and I hope I make justice to this invitation. So let me, Mr. Ashwini, and I'm sorry I didn't get your name, sir. Dr. Sahu, the other speaker, I'm sorry I didn't get your name. He just briefed about what IPR is. We just went through a small shot. Like sir said, definitely IPR, when you're into a research and you would definitely like to get your rights over whatever research that you produce, that is one aspect of patenting, where you get protection for your intellectual property. So be it a trademark, be it a copyright, or be it a patent inventions, you need to have ownership over it. That is one part of the aspects. What I'm going to take you through is another aspect, because you are all into pharmacy. I'm going to show you all another aspect of patents, which is called a patent barrier, as to how patent can impede generics coming into the market, and how this to an extent did it make an impact on coronavirus or the availability of the drugs in the market. So that is what my session is going to be about. I'll just share my screen of the PPT. Just a minute. Is my screen visible to all?
Yes,
Hello?
ma'am.
Yeah, okay,
Yes,
thank
ma'am.
you. Okay. So before I go into what patenting is, I'll just take you a brief through the brief of what IP is. Intellectual property right, like the name suggests, it is the intangible property, the ideas that you create in your mind. And when you express it into different forms, you will want to get a right over it because it is your property, because it is your creativity which you have expressed it. So you have an idea which you express it in, say, form of poems or drawings, you can get a protection under copyright. So your music, your novels, or be it your coding languages, be it now because of the IT revolution, copyright is also extended to broadcasting rights. So that's one of the reasons why you will see, say, IPL match is visible, say, on DD, but is not visible on Star. That because DD has got the broadcasting rights. So these all fall under copyright. The next idea, where you attach innovation or an invention, that is protected under patents. The third type of idea, where you attach a quality or an identity to it, is trademark. So you, what we in short what you call as brand names. So you can see Coca-Cola, you can see Amazon, or you have Flipkart. No other company can be using the same name. That's because they are all protected under trademark or brand names. The third is, if your idea is you attach it with an appearance, a 3D appearance. One of the best examples, and this is something that I always give, an example that I usually give is the, if you can see the shape of the Coca-Cola bottle, it's very typical to Coca-Cola. It's a shape of a woman, if you see. That is restricted. If you see, no other bottles will have a similar shape. So that is just by looking at this shape, even if you remove the label of Coca-Cola bottle, you will be able to identify that the design belongs to Coke. See, design of a Samsung phone, design of a Nokia phone, or a design of an iPhone, they're very specific to that particular brand manufacturer only. Then you have an idea which, if you keep confidential, you do not disclose it, that is protected under trade secret. Now, the difference between copyright, patent, trademark, and design as against trade secret is, if you want protection for copyright, if you want protection for trademark or for design, you have to disclose it. It has to fall into public domain. As against trade secret, if you do not want to disclose your invention, then you can protect it under trade secrets. One of the best examples is the story of Coca-Cola. They say that only the two inventors who manufactured the recipe, Only they know the recipe of Coca-Cola. Otherwise, nobody else in the world knows the recipe of Coca-Cola. That is why Coke till date is a trade secret, and the taste of Coke is very different from any other black Coke drinks. If you see Thumbs Up or if you see Pepsi, they taste different from Coca-Cola because that's a trade secret. It's protected under confidential information. Now, why is IP so important? If you could see on the right hand side below, if you see Bisleri, you see, usually what happens is when you get a protection for any of an IP, you have a negative right where you can stop others from infringing. So stop others from copying your product or copying your trademark or a copyright. But in the form of Bisleri, there was rampant similar looking bottles in the market, the blue color bottles. It was so common in the market that Bisleri had to take an action and they themselves had to change their packaging from blue to green. So now if you see Bisleri bottles, they are no longer blue in color. They are bluish green, sea green color. So that is the impact of IP. They had to change their brand from being blue, their packaging, their product. The whole packaging is called a trade dress and trademark. They had to change the color from blue to green just so that they could distinguish themselves from other blue bottles of packaged drinking water. Okay, so this is a short on what IP is. Brief. This is the briefest that I could give. Now I'll take you to an IP portfolio. If you remember Dr. Nayar's session that we had almost 2 or 3 months back, we did we did show an example of a Cipla inhaler. But here I'm bringing forth to you a Viagra tablet, and the reason you will come to know a little later in the next slides. Now, if you see Viagra, the tablet, that is protected under patents. So it has a US patent for the API for the active ingredient, that is sildenafil citrate. That has a US patent, so it has a protected. The invention, the patent is protected, the technology is protected under patents. Then the name Viagra, that's a brand name. So they also have a trademark protection for the word Viagra. So nobody else can be using the word Viagra. So that's a brand name and the symbol attached to the sildenafil citrate. Then it has an external appearance, the design. The design of Viagra is very, very restricted, very typical to the Viagra tablet. That is the shape of the tablet, which is diamond shape. Blue diamond tablet shape and color. There was a design granted for this shape of blue pill, which means no other manufacturers could be manufacturing Viagra tablets which were blue in color and which were having a shape of a diamond shape. Then it also had a copyright attached to it. That's because the package insert, the dosage that you take or the contraindications, whether you should be taking before lunch or after lunch, by when will the drug start taking effect. These are all protected under copyright, the package insert. Now, other than all of these, there will be some confidential information, probably the particle size that they didn't want to disclose. They didn't want to patent that. So there could be that trade secret attached to it, which is called a confidential information. So you see Viagra, which is protected as a patent because there was novelty, industrial application, and inventive step attached to it. There's a brand name to sildenafil citrate. The pill, the design of the pill is protected under designs. The package insert is protected under copyright, and there is some portion of it which could be confidential information, which is a trade secret, and that is not disclosed. Now, what is patents? If you want a patent to be granted for your invention, it has to be new. That is, it has to have novelty attached to it. There has to be inventive step, which is called as it should be non-obvious to a person skilled in the art. It should have industrial application, which means there should be some utility attached to it, and it should not fall under section 3 or section 4 of the act. So these are the 3 pillars of patentability. So the first thing, that when you arrive at an invention, your invention should satisfy these pillars of patentability. Now, patent, when it is granted, it's a monopoly granted to a patentee or the inventor for 20 years. You will not get a patent granted for more than 20 years. Unlike trademark is lifelong as long as you use it. You have an option of protecting it under trademark where the government issues a certificate, or you did not protect it under a trademark, just your use which means it becomes well known in the market. You don't need to file for an application for a trademark. You ought to get an automatic protection for it, for trademark as well as copyright. But we advise filing or registering a trademark or a copyright because you have a certificate that the government grants to you. So it becomes a proof, a prima facie proof that you are the ownership of that trademark or that copyright. That's one of the reasons why we advise clients to file for a trademark registration or a copyright registration. But for a patent, you have to apply for a patent. You do not automatically get protection for it. And the monopoly is only for 20 years. Now, this is patents is a negative right because it prevents others from infringing the mark. No, you can stop all the competitors, all the generic manufacturers in the market from using your patent, from infringing your patent. A trademark is a positive right because you have to show that you're using the trademark. So even if you have a registration, if you stop using your trademark for continuous 5 years, somebody else can claim your trademark. So trademark is a positive right where you have to use it continuously. The moment you stop using it for continuous 5 years, your protection, you will no longer get protection over it. But a patent is a negative right where you will stop others from using it. You may or may not use the invention. That's a different topic altogether, but just for this session, I think this is enough. You have to remember one thing. This is a question that I always keep getting, whether there is a world patent. There is nothing that is a worldwide patent. If you file a patent application in India, you will get protection only in India. If you want protection in US, you have to file your application in US and you have to prosecute it there. It has to meet these patentability criteria even in US or even in Europe, because patent is territorial. It gives you a territorial right. So where you file it, where the patent gets granted, you will receive protection only in that particular country and in no other country. So there is no worldwide patent. Patents are territorial in nature. Okay. Now, if you see the cartoon that I have on the top left right corner, patent office, you see both the peoples are hiding their invention. So it is very important as far as, because the faculty or the students at Arcagen may be involved in research. So it's very important for you that you do not disclose your research work to any third person, because the moment you disclose it to a third person, it falls into a public domain and it's no longer novel. So if you have any research work or if you have a tie-up with any companies, ensure that you have an agreement, a confidentiality agreement, till you file a patent application. Once you file a patent application, then there is no reason why you cannot disclose it. If you wanted to go for publications, for research publications in any of the journals, ensure that you first file a patent application and then you disclose it into any research journals, because your own disclosure can become a prior art, which means that there is no newness, no novelty attached to your own invention. So ensure that you have confidentiality as far as your research work is concerned. Keep it within the closed network, within your HOD or any students working in it, and see that it's not disclosed to any third person without any confidentiality agreement. Okay, so this was a brief on patents. Now, as a pharma students, you will want to know what are the type of patent applications or what are the type of inventions where you can get a patent granted. So you have patents for NC, new chemical entities. You have for your APIs, active pharma. You have for a product. So your end product may be, say, a formulation, which could be an injection or a film coated tablets or drug eluting stems. These are all product patents. You have for the process also, process for manufacturing of the API, process of manufacturing of any of the dosage of formulations. These are all process patents. Formulation patents, me too derivatives. So for example, there is imatinib, but if your research department comes up with a new drug, which is an erlotinib, which satisfies the patentability criteria, then yes, you will have a patent granted. Dosage forms, release profiles, new drug delivery systems. These are all patentable in India and worldwide too. Now, the last one that I have highlighted is repurposing of the drugs. I'm sure you'll have been reading the newspapers about the regime, the medical regime that is used for curing coronavirus. I wouldn't say curing, but at least curing the symptoms of coronavirus. So, new use of known substances. If you recollect my last slide, I said three pillars was novelty, inventive step, and industrial application, but it should not fall under section 3. Section 3 is very novel to Indian Patent Act because it says a new use of a known substance is not patentable. So, which is what I'm trying to say is repurposing. You'll have heard these words if you'll have read the newspapers on coronavirus. They have been repurposing known drugs for the treatment of coronavirus and its symptoms. So one of the examples I could give you is sildenafil was actually discovered for the treatment of BP, blood pressure. But eventually they realized that rather than treating blood pressure, its side effect, which was erectile dysfunction, it was showing positive effects for erectile dysfunction. So sildenafil for the treatment of BP was known, but erectile dysfunction was a new use of sildenafil. So this is not patentable in India. So any of the repurposed drugs are not patentable in India. See, if you tell me that we know antivirals, if you have heard of the combination of ritonavir and lopinavir, they are antivirals, anti-HIV drugs. These were also initially used for the treatment regime of coronavirus. So if you say, okay, fine, this is something new, I have found for a treatment of coronavirus, the combination of antiretroviral drugs is not patentable in India. Remdesivir, which is a Gilead drug, which was the most, I think, the most highlighted drug. Then you had HCQ. These are all anti-malarials which were eventually used in the treatment of coronavirus. These are all known drugs with known therapeutic indications. They are not patentable for coronavirus in India. Okay, so new use, repurposing, not patentable in India. So let me go to the next slide. Now, what we call this is extending products profitable life cycle. This usually happens in US and EP. Fortunately, to an extent, it doesn't happen in India unless you come up with a new formulation. So I have give you an example of the little pill that is sildenafil citrate. If you see the first patent, which I've highlighted in red, the US 525034 was an API patent for sildenafil, which expired in the year 2012. But eventually they came up with a different dosage. So if you see the nasal administration, that expired in 2018. The chewing gum expired in 2019. Method of treating erectile dysfunction, this patent just expired in this year in April 2020. Then you have the controlled released, you have transdermal patches, then you have phenyl co-crystals of sildenafil. If you see what drug API expired in 2012, the different dosage form has extended the life cycle up to 2033. What I'm trying to say is the 20 years monopoly has not extended. Sildenafil API has expired in 2012, but the manufacturer is still having control over sildenafil dosage forms by filing different types of delivery systems, and they have extended the product profitably life cycle up to 2037. I'll take you to my next slide and I'll show you how this becomes financially important to a company. Okay, so now this is a case of diltiazem, which is an anti-hyperactive drug. So the API, which in 1998 was approximately US $260 million, so that was for 3 or 4 times daily. Then they came up with a 2 times daily, which was a sustained release, which was almost 400 millions in 89-91. Then they came up with a 3 times daily, which was a
Ma'am, you are not audible.
Network issue है. So ma'am is joining very soon. Please wait.
Hello.
Yes, ma'am, you are audible now.
I'm so sorry. Please accept my apologies. I got disconnected.
No matter, ma'am. No matter. Network is.
Sir, I'll just share the PowerPoint. Just a minute.
We are helping here from this side. Abhishek.
Huh.
Abhishek, please run the PowerPoint.
Yes.
Can you please? Yeah.
Is it okay, ma'am?
Yeah, surely, surely. Abhishek, can you just take me to the next slide?
Yes, ma'am. Just a minute.
Yeah, surely. Yeah, this slide. Yeah, right. Now, now, if once the drug comes into a market, now if you know it's a blockbuster drug, what do you do to protect it? So one of the things that Pfizer did, Pfizer was the manufacturer of sildenafil citrate. They tried to maintain the share in this market by launching its own generic version. So instead of a blue diamond shaped pill, they brought it into a white one. And this is how they could continue their monopoly. I wouldn't say monopoly, but their lead in the erectile dysfunction market. The ones that the generic manufacturers were eroding the sales. So to maintain their stand, to maintain their lead in the market, they came up with their own generic version, which is a white pill, and they continue to maintain and be a leader in the market. Abhishek, next slide. Yeah, I'm done with this side. The next one. Yeah. So now we come to coronavirus and what is the impact of the pharma industry on coronavirus and the availability of the drugs in the market. The next slide. So if you've seen this slide, I've taken it from the net. If you see, there were different types of drugs which were suggested for the treatment of coronavirus and how different drugs could impact different pathways of the virus. So you had your monoclonal antibodies which impacted the spikes of the coronavirus, or then lopinavir, ritonavir, which had impact on the proteolysis of the coronavirus, the replication at different stages. So different of all these molecules, what I'm trying to say is that these are all known molecules and they were being repurposed for the treatment of coronavirus. I go to the next slide. Now, at this stage, I just want to say that we are very proud at Dr. Nayar's office, where we were part of a team where Dr. Nayar, under Dr. Nayar's guidance, Dr. Nayar was the advisor to the T-Ford. Now, this T-Ford, that is the coronavirus force, was constituted by the principal secretary, who was the advisor to Honorable Prime Minister Modi. So we were in the team where we were advising. So in the first 3 months of the COVID pandemic, that is in March, April, May, we were working with the government on how to overcome the patent barriers on most of the drugs that were being used for the treatment of COVID, for the reason that some of the drugs were patent protected while some of the drugs were free. So we worked on these projects. Can I have the next slide? If you see this, these were the drugs that were suggested by different advisors. The advisors came from KEM hospitals and various other hospitals and organizations who suggested that these drugs could be the line of treatment of coronavirus. So we had around 29 pharmaceutical molecules and 9 phytochemicals where we had to ascertain the patent status and provide ways to work around if there were any patent impediments. So if you see the ones which I have made in blue color and highlighted, these all were patent protected. So Remdesivir has a patent protection up to 2035, which means no generic manufacturer who is unauthorized or who has not taken permission from Gilead can manufacture Remdesivir. So no generic manufacturer without the permission of the innovator. Similarly, Tofacitinib, which is protected up to 2022, and you have the blue highlighted drugs. The ones in the red were free to manufacture. Any generic manufacturer could manufacture generic drugs and market them, and these could be used for the treatment of coronavirus. Next slide. So what we basically did was divide these drugs and the phytochemicals into 3 categories. So you have 100% FTO, 50% FTO, and no FTO at all. When I say FTO, it means freedom to operate or freedom to market these drugs. So 100% FTO, hydrochloroquine, these Dr. Nair calls them grandfather drugs because these have been known since ages, chloroquine and hydroxychloroquine. There was 100% FTO. So the generic manufacturer could just take permission from the FDA, manufacture, get the manufacturing license and market the drugs. No fear whatsoever of being infringed. The others were 50% FTO, where the API, the first patent on the API were expired, but there were some follow-on patents such as formulation patents which were still protected in India. No FTO, which means you could neither manufacture the API, not any of the formulations. If you did any of these, you would be infringing the patent. The next slide, please. Yeah. So this is one case study of no FTO, Remdesivir, because this is the lead in the treatment of coronavirus. So if you see, there are 3 patents for Remdesivir API. I'm stressing on the word API because there are other follow-on patents for the formulation and different dosage forms, but these are only API. So technically, if you look at it, the patent should have expired in 2029, but no, the API doesn't expire in 29, but the API expires in 2035. Why? The reason being, the first patent, which is the 275967, is a genus patent, which means it's the basic patent, the basic structure of the scaffold along with the substituents are protected. And they said that this is a generic disclosure. Specifically, Remdesivir was not disclosed in this patent. Specifically, the R-diastereoisomer was protected in a second patent, which is 319927, which they called it a species patent. But the bug doesn't stop here. They filed another Indian patent, which is 33280, which is also a selection patent. But they said this is not the R-diastereomer, this is the S-diastereomer. And this is the one which has enhanced efficacy, enhanced therapeutic efficacy in the treatment of the disease. So, which means in short is no generic manufacturer can manufacture API. The active pharma ingredient cannot be manufactured up to 2035. So they have protection, they have monopoly over the S-diastereoisomer, which is actually the active form of Remdesivir, and it can be done only after expiry of 332280, which is expiring in 2035. Next slide. So if you ask me what you mean by generic disclosure, what do you mean by a genus patent? What do you mean by a specific patent? What do you mean by a species patent? So this is a type of a claim. So what we call generic is a Markov structure. So if you see, this is compound of a general formula. There is a formula given and there are substitutions. So R1, R2, R dash, R4. So you will substitute each one of them and arrive at a structure. So what Gilead says is the first pattern is there is a specific, there is a Markov structure, but it is the second patent which specifically discloses remdesivir. So that becomes a species patent, that becomes a specific. So the first patent has all the possible substitutions. This is a very minor example that I'm giving you. These kind of substitutions can run into 100 pages also. So the specific structure is not disclosed in the first patent, but along with the substitution. So we have to actually sit and substitute R1, which could be either trifluoromethyl, or it could be hydrogen, or it could be a halogen. In some patents, there are almost thousands and thousands of substitution just for R1. So these are all genus patents. These are all Markov patents, or what you call them, a generic disclosure. There is no specific. So when I substitute a compound, I can come up with a structure. So I've given one example is of regorafenib and sorafenib. If you see, the difference in the two structures is only with the fluorine and the hydrogen molecule. Just with a single substitution, regorafenib regorafenib becomes a sorafenib. So this is how patentees continue to have monopoly over their blockbuster drugs. Next slide. Hello.
Yes, ma'am.
Hello.
Yes,
Yes,
ma'am. You
ma'am.
are
Yes,
audible.
ma'am. You are audible.
Yes, ma'am.
You are audible, ma'am.
Generic patent expired, but the species patent, the specific patent was yet to expire. So one of the cases was dapagliflozin. Now this is an anti-diabetic drug that is also used in the treatment of coronavirus as a add-on drug. Now Justice Rajiv Shekadar, he passed a judgment in the Delhi High Court on 2nd November by saying that I cannot continue to give you protection for dapagliflozin, especially since the genus patent, you have already said that the genus patent, the first patent, is disclosing the drug. So how can you continue to have monopoly over DAPA when you have already disclosed the drug in your first patent? So here the court didn't only take into consideration the patentee and the defendant, that is the generic manufacturer, but it also took into account the public interest, whether the public will be suffering merely because there is a dispute on the patent. Now if you see the drug, the manufacturer, the generic, the price difference between the generic and the innovator was almost 250% to 350%. Hence the court had to intervene and pass an order that no, I will not stop the generic manufacturers from continuing to manufacture the drug, but at the same time, because this is law, we talk of equity, which means both the parties have to be equally benefited. It should be a win-win situation. So the court said that the generic manufacturer can continue manufacturing the drug at cheaper prices, but the generic manufacturer will have to submit their statement of accounts, which means how much is being sold, where the drugs are being sold. So they will have to make statements and submit it to the courts. So this is a very recent judgment, and this was a landmark judgment because this was required at this stage, especially because looking at a country like India, where it's important that blockbuster drugs are available, not only available, but they're also cheaply available to the citizens of India because we are not like the developed countries. Not everybody has insurance. So the court had to intervene here and pass an order in public interest. They had to intervene in this matter. The next slide. So what we saw now was 100% FTO. So no generic manufacturer could manufacture the API, neither the formulation. There was a second part of a project where we gave a partial FTO. Partial FTO because tocilizumab API, the active drug, was not protected in India. They did not file a patent in India, but they filed a formulation patent in India. So we had to inform the government that the API is free for manufacturing, but the formulation patent is not free for manufacturing. So what you have to do is, if there's a formulation patent for a patent, the generic manufacturer can come and work around a tablet patent and can come up with, say, a injection patent or a patch patent, a transdermal patch patent. So API was free to manufacture. Formulation was also free, provided you're working around the patented invention. Similarly, there was an invention, similarly, interferon beta. The formulation and the API patent were free. There was no FTO, but the dose, the injection, the pre-filled injection, with an auto injector is valid in India up to 2026. So the API and the basic standard formulation was not protected in India, but the pre-filled injection is protected in India. So this was, therefore it was a partial FTO, because you can work around this by coming up with a different formulation. Next slide. Yeah. So these were all about the project that we did. So we gave 100% FTO, partial FTO, and no FTO at all. So no FTO was HCQ. 100% FTO was HCQ. So I don't have to speak about it. So any API, any dosage form, free for manufacturing by the generics. Now, how does the government intervene in all these? Now, you know, Gilead is an MNC, which is a US based company, and they have a protection in India. Similarly, they have patent protections in almost 50 to 60 countries where they have filed a patent application. So in almost in around August to September, India and South Africa, they made a proposal to the World Trade Organization. Now, just to give you a brief, every countries are member of most of the countries are signatory to WTO, that is the World Trade Organization. And World Trade Organization administers IPR treaties. So TRIPS, trade related aspects of intellectual property rights. This is, I would call, as a umbrella kind of a treaty, which which sets minimum standards for each intellectual property rights. So be it intellectual patents. So be it copyrights, be it trademarks, be it patents. If you're a member of WHO and if you're a signatory to the TRIPS agreement, you have to follow the basic minimum standards that are cited in the agreement. So India and South Africa made a proposal to WHO, and they said, please waive the implementation and application and the enforcement of Section 1, Section 4, Section 5, and Section 7 of the TRIPS agreement. They said, please don't enforce any of these as long as the COVID pandemic is alive in the world. But there were oppositions by developed countries. For example, UK said that we cannot agree to this proposal and we cannot implement all of this. We cannot give a waiver for these sections that have been sought of by India and US. So what next? Now, definitely they had a meeting in October 2nd or 3rd. They had meetings at the WTO, but they did not agree to this proposal. So now the next meeting comes up in March 2021. But why did UK not agree to this proposal, especially looking at the increasing number of cases? Why did they want to continue to enforcing their rights in patents, trademarks, or copyright? The reason being, I'll let you know why. The next slide is the statutes. Next slide. Now, when you become signatory to TRIPS and the WHO, we had to change our laws. We have to agree to the minimum standards. So like I said, patent monopoly, 20 years, no generic manufacturer, no competitor in the market. But this grant of a patent is subject to certain conditions. So if you see section 47 of the act, it says, in respect of medicines or drugs, if you are if it is being imported by the government or it is being used on behalf of the government, the patentee cannot come and sue you for infringement. So this is an exemption under the act. So you may have got a patent, but if it is a medicine or a drug, and if there is a situation like a pandemic, you can manufacture the drug. Either the government can manufacture it on its own, or the government through tenders can make any of the generic manufacturer manufacture these drugs. Next slide. We also have other sections in the act, such as section 83, 84, 99, 101. Some of these sections talk of voluntary license. So voluntarily, as a generic company, you can go and approach the patentee that please give me a license, grant me a voluntary license. There is a tech transfer from the manufacturer, the MNC, to the generic manufacturer. Then you can manufacture the drugs at a cheaper rate. One example of this was sorafenib tosylate. This was not a voluntary license, but a compulsory license. Voluntary license, the manufacturer will voluntarily grant a license to you. But what happens when the manufacturer declines your request for a voluntary license? Then you can approach the government, that is the patent office, for a compulsory license. The patent office will compulsorily grant you a license. So this, the only case in India is the sorafenib tosylate matter, where a voluntary compulsory license was granted to NATCO. Similarly, there are other provisions in the act where even if you have a patent, the government can intervene and ensure that drugs are being manufactured by any of the generic manufacturers. Of course, this is not a blanket manufacture. What happens is the government will have to decide on some royalties that is being given to the manufacturer, the patentee. So the patentee will get royalties and the generic manufacturer will continue to manufacture. Now, these compulsory license provisions that I have depicted here is not only in India, but even the US has provisions such as compulsory license, which is 28 USC code 1498. Similarly, Europe, Thailand, Canada. In fact, some of the countries after the pandemic, when the WHO uh, uh, WHO announced that this is the pandemic, most of the countries granted compulsory licenses willingly, where any of the generic manufacturer could manufacture any of the drugs which had patent protection. But in India, till date, there is no compulsory license or any such kind of licenses which is granted by any of the and by the government. But the government, I have read in the news that the government of Maharashtra had imported drugs from Bangladesh. So Bangladesh was manufacturing Beximco, which is also our client. Beximco was manufacturing generic drugs in Bangladesh, and when remdesivir, the quantity of remdesivir had gone down, the availability of remdesivir injections when it went down, Maharashtra government imported it from. So the Maharashtra government didn't have to take permission from the patentee. They could import the drugs from Bangladesh because they had a right under the Patents Act. The next slide. So what I'm getting to is the government use. There is a sovereign immunity. So the government, the patentee cannot sue the government because the government can make use of these provisions because COVID is a pandemic. Because COVID situation enables you to enact one of these sections from the Patents Act. So the government can use the invention for its own use. So in its dispensaries, in any of the municipal hospitals, it can manufacture and market the drugs, or it can even import the drugs like the Maharashtra government did. Or it can grant licenses by through tenders to another manufacturer, generic manufacturer. And if any of these don't work, the government can also, there can be acquisition of invention, which means the government will take over the technology from the MNC, and the MNC will no longer be able to do anything because they will acquire the patent. Licensing is different from acquiring a patent. In licensing, the ownership continues to remain with the patentee. But when I acquire the invention, I become the owner of the patent. It's no longer licensee. The patentee cannot do anything. The ownership changes from the patentee to the acquirer. So this is also possible under government use. So it is like in US, it is use or manufacture by the government or for the government. Next slide. Yeah. There is a section 107A which is very important to students and pharmacy students like you, especially at Arka Jain University. You will say that okay, you are a research student, you would like to go through any of the patents and decide okay fine, this patent between the dosage form of 75 and 100 mg is available patented, but you realize that at 0.5 mg it works even better, the API works even better. Then what? You will be worried whether you are infringing the patent or not because you are working the invention in your lab. I would say do not fear, बेफिक्र होके invention को work करो अपने research labs में, because there is an exemption of 107A under the act. These are research exemptions which are also called as BOLAR provisions in US, which means you can any act of making, constructing, using imported or patented product reasonably required for development purpose, for research and development, for dossier submissions, or even in your lab for education purposes, will not lead to an infringement of a patent. And this particular section has been upheld by the Delhi High Court, which said that yes, this is an exemption under the act where you as a research student or you as a research faculty or even a generic manufacturer can manufacture the drug for the sake of dossier submissions at the FDA. So this is all exemption against patent infringement, that is 107A. Next slide. Now, these all, if you will ask me, where did India come up with all these provisions? These provisions are because we are signatory to WTO, World Trade Organization, and the TRIPS. So, para 5 of the Doha Declaration says that each member has the right to grant compulsory license and freedom to grant rights upon these licenses. They have a right to determine what constitutes a national emergency or circumstances of extreme urgency. So there are provisions, there are statutes where the government can make use, and even if there are patents, valid patents in the market, these provisions can be put into force, and these have been adopted by WHO because they want to circumvent patent rights for better access to essential medicines. Next slide. The TRIPS. You will ask me where the TRIPS is. So if you read Article 30 and 31, it allows for member countries to use a patent without the authorization of the patent holder. So you don't have to go and seek license from the patent holder. If the government notifies, any generic manufacturer can start manufacturing the drug. Next slide. This is Article 3A, which says that you can grant compulsory license to prevent the abuse which may result from exclusive right conferred over, but with certain limitation. This is the Paris Convention. India is treaty to Paris Convention also. So compulsory license is granted because they should not allow the patent holder to abuse rights. See, they say patents are granted for innovation because it becomes like an incentive where you can manufacture even better drugs. But at the same time, if you are the manufacturer, if you are a patentee, it should not lead to an abuse of your patent rights. The drug should be freely available, reasonably available. Maybe not at all times, but during a pandemic like COVID, it should be available. And in fact, if like I said, if you've been reading newspapers, at one point of time, remdesivir was not available in the market. People started black marketing the drugs, black marketing remdesivir. This situation should not have arisen at all because there are provisions in the act where you don't have to even seek the patentee's permission. The government can just notify and you can start manufacturing the drugs. So the issues of unavailability of drugs, the issue that the drug was not reasonably available in any of the hospitals should not have arisen at all, because there are provisions under the act which the government should have put into use. The next slide. Yeah. So what do you do? Now I have just brought for this whole scenario to you. So you have two options. If you're a generic manufacturer, you either work with the IP dolphins or you fight it. So when I talk of working with the IP licenses, Remdesivir, now the government may not have notified it. One reason could be because Gilead had willingly granted voluntary license to several Indian generic manufacturers. So they themselves decided that they will give licenses to generic manufacturers. There was a tech transfer also. Now I am in support of voluntary license because voluntary license doesn't just give a license to manufacture, but there is a tech transfer also. So the generic manufacturer doesn't have to reverse engineer the drugs. The patentee themselves shares their technology. So the process of manufacturing, the standards that they have to maintain, these are all already shared in the voluntary license. So this what happens is it shortens the time for the generic manufacturer to bring the drug into the market. As against compulsory license, there is no tech transfer, but the compulsory license C, that is the generic manufacturer, they themselves have to reverse engineer the drug, come up with their own process, come up with their own standards, and meet the requirements of the FDA. So I am in all in support of a voluntary license, like Gilead did in terms of Remdesivir. And in fact, this was a royalty-free license. None of the generic manufacturers have to pay royalty to the MNC, to Gilead, as long as the pandemic situation prevails. Even for tocilizumab, Roche had willingly granted a license to Cipla. Now, if these options don't work, if the patent is not willing to grant you a license, you have an option of fighting it. That means you approach the court like the generic manufacturers did in the case of dapagliflozin. They approached the court to try and amicably settle the matter. So another case is Gilivik, which is the mother of all the cases. It's a precedent as far as pharmaceutical cases concerned. If it does interest you, all you have to do is just put Gilivik Novartis case in India, and you will get innumerable articles and publications on the case of Novartis. So this was a case of 3D of an invention which was already known. There was no novelty. It couldn't satisfy the patentability criteria. Hence, patent was not granted for Gleevec, which is imatinib mesylate. The next slide. Yeah. So these are the strategic options that you have. So if you are a researcher, you have an option of patenting. If it's patentable, you will get a patent granted for your invention. You have an option of licensing in or licensing out, like Gilead did in Remdesivir. It licensed out. There was a tech transfer also when it licensed out. You can license in your technology also. There are voluntary licenses where the MNC will voluntarily license the patentee will voluntarily license their inventions. This license could be exclusive, which means they're granting the license only to one licensee, or it could be non-exclusive, which means there could be more than one licensee as far as the transfer is concerned. Compulsory license, it could be private, like in terms of sorafenib, it was only NATCO who could manufacture the drugs under compulsory license, or the government it could issue licenses for more than one generic manufacturer. If you want to fight the IP sharks, which are the patentees, you have an option of opposing the patent or invalidating the patent. So then the patent is no longer alive, or you have defense in the high court, the counterclaim. This happens in the high court, where you say that the patent is not valid. It should not have been granted in the first place because there is no patentability attached to the invention. So you can file a counterclaim to revoke or to invalidate a patent. These are the strategic options that a patentee and a generic manufacturer has. Next slide. Now I have given you some type of what I spoke so far was only pharma related, but there are some other coronavirus related applications also. So I've just given few, just around 4. There are n number of applications. If you do a search in Google or Google patents, you'll find many patents. So there is an Australian patent application which talks of a AI based mask for which a patent is still pending. There are two. One is a smart COVID scanner. There is a mask. Then if you see serial number 3 and 4, there is already a patent granted in US for SARS-CoV-2, that which is the coronavirus, the current pandemic. So there are patent applications other than pharmaceuticals. There are other kind of patent applications which are filed as far as coronavirus is concerned. The laws, the statutes are the same, whether it's pharma, whether it's mask. They say that N95, there are the masks that we are wearing, the N95 masks also have some patents to them. This, in fact, there are different types of filters and all which also have patents attached to them. So if any manufacturer wants to manufacture the mask also, they have to take permissions from the patentee. So the workaround solutions as far as the pandemic is concerned, either the manufacturer will license it or the government will intervene by issuing notifications that yes, you can manufacture this. You either pay royalty to the patentee will accept a royalty, or they will say okay, this is a royalty free transfer licensing of the patentee. So this was on coronavirus and the pandemic and how its impact is as far as patents is concerned. And this is my last slide. If you have any questions for me, do let me know. Other than these, if you want to know if there are any career opportunities or any patent related, trademark related questions, please let me know.
Yes, ma'am.
Hello.
Hello.
Sir, I'm ready to take questions or any.
Yeah, yeah. Is there any role of pharmacovigilance?
Pharmacovigilance in terms of what, sir? I mean, this is purely patents, sir.
That I am telling.
So,
What my doubt is,
uh-huh.
suppose name, but thing is that for formulations,
Yes, sir.
we have paracetamol with us. We
Yes,
have
sir.
certain molecule with us.
Yes,
We are
sir.
formulating by different manufacturers in different doses and different
Yes, sir.
formulas.
Yes, sir. Yes, sir.
So we can go for the patent of that one.
Definitely, so you can go for a patent, but to go
After,
for a patent,
after that,
as a one thing is there. Any invention, any research work that you come up with, the first thing that you have to do is to do a prior art search, which means to ensure that you're not reinventing the wheel, which means that that particular invention is not already in the market. So there is no novelty factor. Your invention, your research work, there is a novelty attached to it. If you meet the patentability criteria, then you can get a patent granted for an invention. You can come up with any type of dosage forms, even if the molecule is a grandfather molecule. If you come up with a dosage form, you will get a patent granted. If it's a different dosage form and there is no similar kind of formulation in the market, sir. This is restricted only to patents, sir. Novelty, inventive step, industrial application. There is no pharmacovigilance attached to this, sir. That's a totally independent subject.
okay, I think that after the formulation, the manufacturers are going for that pharmacovigilance.
Yes, sir.
So
Yes, sir. They're two independent
that is what
domains altogether. Yes, that's a different. The
that are the role.
pharmacovigilance is at at the FDA, the DCGI. This is at the patent office, which is a different
Yes.
altogether, different domain altogether.
No interference.
No, sir, not at all.
Before that, we have to go for this patent process.
Yes, sir. Before you disclose or before you go for any of your submissions, the moment you realize that yes, this is a patentable invention, ensure that you file a patent application. What we call it as a provisional patent application. If you're not sure of the ambit of your invention, that okay, what should I cover? Whether should I cover A to B or B to C? You will have 1 year to do that. So you file a provisional application, you will become the owner on the day you file your application. That becomes your filing date or your priority date. Then you'll have 1 year to file a complete where you file the claims. The claims is the ambit of the protection of your invention. So the moment you have an invention, file a patent application. But first you conduct a search so that you are not reinventing the wheel. So which means that somebody else should not have already protected that invention. Otherwise, you will not get a patent for that.
Sometimes, ma'am, during invention of something, we may go for some negative result.
I'm sorry, sir. Negative?
Sometimes negative result, toxic result, which may not come in the beneficial of the society.
Okay.
Whether at that moment, how patent will be impacted or affected?
So that's what, sir. The toxicity levels, that the patent office is not concerned of that at all, as long as you can show that there is some kind of therapeutic efficacy, which means there is some kind of what you say, industrial application for it. They are not concerned with the toxicity level as such, because you wouldn't have done your clinical trials by then. When I say that your file an application the moment you realize you have an invention, till then you may not have even done your, your clinical trials or even your in vitro level trials. You may not have done it. That is not an issue here, sir. The patent office is only concerned if there is a novelty, inventive step, and a utility attached to it. So if you have a formulation, say you have come up with a tablet formulation, you give one example. So one example in the, we call it as a complete specification. One example is more than enough, and you say that this is for the treatment of XYZ. That is enough, sir. You don't have to worry about the toxicity level as such, unless the patent office thinks, okay, they want to know.
Thank you.
You're welcome, sir.
So Smriti ma'am, any other questions from any other?
Any students or anything, I'm willing to take any questions. Not only attached to this, my topic, but any other questions also. Sir.
Yeah, please. Sumant sir, any question from your end?
Yes, sir. Namaste, madam. Myself, Sumant
Namaste.
Bhushan, Associate Professor, School of Pharmacy, HGU.
Yes, sir.
Madam, actually, my field of interest is transdermal drug delivery system, which you told. Okay.
Yes, sir.
So, during our research, we found with the master students that is in formulation, one of the standard penetration enhancer. In transdermal, basically, we are applying topical. So
Yes.
the drug has to be penetrated through the stratum corneum, the outermost
That's
layer.
right. Yes, that's right.
One chemical entity we are using that is known as your DMSO, dimethyl sulfoxide.
Okay.
But it has some typical side effects. Okay.
Okay.
So we tried with some natural agents. Okay.
Okay.
We found it has a tremendous effect in the penetration of drugs.
I
Okay,
hope
still-
now, I'm sorry to interrupt you. What you're telling me, I hope you have kept it confidential, because now it's coming. You're revealing it to everybody here, to the students. This is
No,
what I've been
that-
stressing upon. Huh.
That extract is secret to us. Okay.
Yes.
We isolate from the plant
That's
sources.
right. You keep it like that. Okay.
So we found it has a very much penetration enhancing efficacy. And we found there is no such toxicity or sensitivity reaction to the skin. So shall I modify that formulation and go for because
You
today we
can.
came
The
to-
formulation doesn't. Sir, whichever formulation is not an issue, because you just told me that there is a therapeutic efficacy to it. You just realize that when you add a natural product B to your existing formulation, you have found better results. So I would suggest to you is that if you are going for a patent application, search the closest. For example, if it was a transdermal patch only with the active A, with no external enhancers, the results came to you was XYZ. So this is your closest. But when you added B to it, your results came as XYZ raised to N, which was enhanced. So you have to compare these results and put it in your specification by showing that how yours is better than the prior art. Basically, what you're doing is showing how yours is technically advanced. So that is what you can do. You can show in terms of numbers, statistics as to how yours is better than the other prior art. But sir, there is one thing. What I spoke was patents, but since you said that there is some natural product, plant-based product, there is something called as a Biodiversity Act. That's a different independent topic altogether. But just because you just mentioned herbal, in the Biodiversity Act, it says that if you're making use of natural products which are naturally available in India, you have to take the permission of the Biodiversity Act also. So when you file an application, patent application, there is something called as Form 1. In the Form 1, you have to tick mark certain criterias. One of the tick mark that you have to do is whether you're using natural resources. If you're doing natural resources and you have ticked that column, you have to inform the Biodiversity Act, and they will make you sign an agreement by saying that when you're commercializing this drug, there is some kind of percentage that you have to give to the Biodiversity Authority. Now, this is for a reason. Biodiversity Authority came into forces because the natural resources that were being used because the farmers or the Adivasis, they had to be equally benefited from your use of the drugs. So that percentage that you give for the BDA, Biodiversity Authorities, that is part of it is supposed to be given to farmers or the Adivasis who are growing it. So if you're making use of any natural resources, you have to ensure that you inform the patent office and the biodiversity authorities from where you're using the plant resources. You don't have to worry about it. The patent attorney takes the responsibility of how to respond to the BDA, the Biodiversity Authority. But you have to inform is what I'm trying to tell you. So
Actually,
any
madam,
use of natural products.
I also collect that from the rural area. That extra
So that natural extract you have to inform the controller. You have to take permission from the BDA that yes, I'm using so and so natural product from so and so place. So you have to inform the controller, not now, not during your research work, but later on, if you think of filing a patent application, you have to make a mention to the controller, seek permission from the BDA authorities.
Okay. One more question, madam.
Okay. Surely.
Madam, that is one drug is there that is already established to treat breast cancer. So that is, but it has a secondary complication that is called your cardiomyopathy. So that's why the patient after curing of breast cancer, there is a chances of death. Okay. And we found that is related to the dose. The dose of that chemo is some extent high. So that's why that secondary complication occurs and due to cardiomyopathy.
So basically, you have a synergistic effect as far as your drug with the phytochemical is concerned, right?
No. The drug is same, madam, but the doses form we changed, and we tried to reduce the quantity of that drug.
Okay, so basically, with your formulation, the side effects are reduced and the death rate is reduced.
Yeah.
Okay,
yes.
Excellent. Okay, sir. So these
in
are
that cases we can also go for.
You can, and you have to mention these advantages in your specification as to why you decided, how you are overcoming the drawbacks of the for the initial the only the use of the API, how you're overcoming that. So you're overcoming that by using a phytochemical. So you have to mention this advantage in your patent application when you're going to file a patent application. Okay.
Thank you so much.
You're welcome. Any questions?
Ma'am, do we have any more questions from any of the students?
Any job prospects also, I'm willing to take those questions also. If anybody wants to know about the field of IP.
Good afternoon, ma'am.
Good afternoon.
This is Nidhi. Ma'am, I want to know about nuclear pharmacy.
Okay.
Yes, ma'am.
What exactly would you like to know about nuclear pharmacy? I mean, be a little more specific.
Yeah, ma'am, I want to know about it. What are the scopes for in that?
No.
I suppose I'm not the right person for that.
Sorry for interrupting.
No, it's okay. But if you I'm sorry to interrupt. If it's only nuclear the field that you just mentioned, if you're only interested in that, then I'm not the right person. But with that field, if you want to practice as an IP, you can do that. You can become a patent practitioner with that background also. Like for example, I have a background of microbiology and biochemistry and my master's in biotechnology. But in the field of patent, you can have a complementing synergistic effect of your law degree and your science degree. So yes, with that degree, you can become a patent practitioner also if that is your interest. Okay.
Okay, ma'am. Okay.
Yeah.
Smriti, ma'am.
Yes, sir.
Please.
Okay, sir.
Please go ahead to conclude this.
Thank you so much, ma'am, for the
Thank
talk.
you.
It was really, though it was the second time that we met you again, and it was really very informative session, and hope we get your cooperation in the future events as well.
Surely.
So now I would request our Dean, Sir Dr. Jyotirmay Sahu, to kindly give the token of appreciation to Andrea, ma'am. Over to you, sir.
Thank you, ma'am. A small token of appreciation.
Thank you. Thank you, sir.
Thank you, ma'am. And we will seek definitely your cooperation in the future.
Surely, surely, for anything, sir. It's my pleasure to be part of the session, sir. Thank you. Thank you, sir. Thank you. Have a good day.
My regards to Nair sir.
Sure. Thank you, sir.
Best wishes to GNA.
I will convey your regards, sir.
Thank you.
Thank you. Thank you so much. Have a good day. Bye-bye.
Thank you so much, ma'am. Thank you so much,
Thank
sir. So before ending the event, so I would request everyone to kindly stand on the respective places for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you so much for the event, sir. Thank you, everyone.